Welcome, everybody, to our webinar today on damages in fair housing cases. Thank you for registering. Hope you find the time well spent. So again, this webinar is going to be recorded. Please put your questions in the Q&A, not in the chat. Closed caption is needed. You can click on it. And this webinar provides general information for specific discussion or consultation in terms of a particular case. Please contact our office at 313-579-FAIR or info@fairhousingdetroit.org. Those are the short ground rules. And this video will be being recorded, will be posted on our website under services and resources. There's other webinars there as well. I'm also going to put the PowerPoint there as well. And then there's going to be a worksheet on damages. I'll have that there as well. And there's other videos of other webinars or conferences. Thank you for MSHDA for sponsoring this webinar. We have a series of webinars that are being offered on fair housing topics. This is one in the list of them. Appreciate MSHDA for the support. Questions are always welcome. Please use the Q&A, not the chat. So here's the challenge in determining damages in fair housing cases, right? The challenge that you face is this. It's since the passage of the Fair Housing Act in 1968, judges have had a difficult task assessing damages to victims of housing discrimination. This is Judge Heifetz and Heinz. They were administrative law judges that heard HUD, ALJ cases, administrative law judge cases and fair housing cases that are going through the HUD administrative process. And they point out these factors include considerable variation in the size of damage awards in districts over the years, history of cases with no apparent nexus or connection between evidence of actual injury and the award of damages to the complainant, the difficulty of quantifying intangible injuries, and few decisions explaining the basis for the award. So they found it difficult to come up with the value of damages in fair housing cases. Professor Schwem, he's the leading professor in fair housing cases. He says pretty much the same thing. Decisions provide little guidance in assessing the amount of awards. There's great variation in the awards, some only nominal damages of $1, and others over 20,000. And this is written 40 years ago, so it's much higher than that, but there's still that variation. So he points out the same thing, that they really didn't explain what the basis is or satisfactory explanation what the basis is for the monetary award. And so that's a concern. Practically speaking, we deal with that as well, right? And looking at a fair housing case from the perspective of a plaintiff or a complainant, is it worthwhile to challenge what occurred? What's likely to be recovered, if anything? From an attorney's perspective, what are the damages? I always ask that. Without understanding likely or possible outcomes, it's difficult to arrive at a strategy for handling the case. Probably the first question, not the last, should be, what can be obtained or recovered? Is it worth the trouble? And so we're going to look at that. We're going to start off with, these are the four parts that we're going to cover here. Just sticking with damages, pretty much. And I'm including attorney fees too, because I think that's often is treated as an element of damages. We're going to do an introduction briefly and looking at fair housing policy, sample verdicts. Then we're going to go through quite a bit of discussion with compensatory damages. Part 2, we're going to cover punitive damages and civil penalties. Part 3 is going to address attorney fees. And part 4 is going to be a recommended approach in quantifying damages. So first one is this, fair housing policy and sample verdicts and compensatory damages. First of all, the major fair housing laws, there is the Federal Civil Rights Acts of 1866 and 70. They're commonly referred to as sections 1981, 1982. That's the bedrock fair housing law. The Fair Housing Act adopted in 1968. It was amended in 1988. We're going to look at that as well. There's other federal laws that are important. There's Equal Credit Opportunity Act, Title VI of the Civil Rights Act of 1964, and the Americans with Disabilities Civil Rights Act and Section 504 of the Rehabilitation Act of 1973. The major, at our state anyways, Michigan fair housing laws are Michigan Elliott Larson Civil Rights Act and the Michigan Persons with Disabilities Civil Rights Act. What stands out right away, the key difference between most of the federal laws and our state fair housing laws is that The Elliott-Larsen Civil Rights Act and Persons with Disabilities Civil Rights Act do not provide for punitive damages. They permit compensatory damages only. As a result, because punitive damages are an important component in fair housing cases, it's always important to allege and preserve claims under the Fair Housing Act in sections 1981 and 1982, if at all possible. In this brief webinar today, we're mainly going to address two federal fair housing laws, the Fair Housing Act in sections 1981, 1982. And just a kind of quick summary as to differences between the Fair Housing Act, sections 1981, 1982, and other fair housing laws. You know, we are basically, when it comes to federal civil rights protection, it's very, very much a patchwork of protection. So first thing, under the ADA and section 504, there are no punitive damages. Those statutes involve or require that there be some type of federal financial assistance. They consider that, like Supreme Court says, contract clause claims, but there's no punitive damages under those claims. There's also barriers to emotional distress damages under section 504 and the Affordable Care Act. That's based on the Cummings decision. I have the citation there on the right of the screen. By implication, the discussion in Cummings would apply to Title VI and Title IX. Here's the issue with that. It came out actually after Cummings was decided. There was an employment discrimination attorney in DC. So, basically it's wrong. So Cummings says there's no emotional distress damages recoverable under section 504 in the Affordable Care Act. That's the holding in Cummings. By implication, the other contract clause claims, Title VI and Title IX, would result in the same result, probably going to be held that way. The problem is this: if you trace through the regulations, for example, 29 United States Code, section 79, 4A, sub A, sub 2, you have to go to 42 United States Code 2000E-5E 3B. Then you go to 42 United States Code 1981A, A2, and B. It will show there that emotional distress damages are recoverable. The problem is you got to jump through so many statutes to reach that conclusion. So Cummings said basically you can't get emotional distress damages under 504 and the Affordable Care Act because there wasn't really a clear expression of intent to impose that type of liability under those statutes. Well, the fact of the matter is Congress did in fact do that. And that is the notice that is required to be given to recipients of federal financial assistance. But you have to go through several hoops. Congress probably should have just done it straight up. And so the long and short of it is, yes, there are emotional distress damages under the section 504. The Affordable Care Act incorporates the damage provisions of section 504. So basically Cummings is just wrong, just a wrong decision. Mistakes get made. Mistakes is made in the briefing all the way through the district court, Court of Appeals, and Supreme Court. It just got missed. So anyways, I'm arguing it, and at some point Cummings has to be set aside. It's just wrong. It's not often that you can say it, but sometimes decisions are just wrong, and they are. And with a minor exception, we'll see it in a second. The Equal Credit Opportunity Act caps punitive damages at $10,000. The long and short of it is the best ones for damages are the Fair Housing Act in sections 1981 and 1982. That you get the full measure of relief. So what do we have? Sections 1981 and 82 covers residential and commercial properties, and the protected class categories are listed on the screen. And you can get compensatory and punitive damages with no statutory limit. That makes sections 1981 and 1982 different than Title VII or different than the recovery under 1981, 1982 when it comes to employment discrimination cases. In employment discrimination cases, there's caps on punitive damages, there's caps on compensatory damages, there's no caps under sections 1981, 1982 when it comes to fair housing claims. The Fair Housing Act is limited because it only covers residential properties. I have the 7 protected class categories listed, and it provides for compensatory and punitive damages with no statutory limit. Congress set aside the statutory limit in the 1988 amendments. Equal Credit Opportunity Act has additional protected class categories beyond the Fair Housing Act. That only covers lending or financing transactions, but it also includes marital status and age, and also rights exercise or income through any public assistance program. Also rights, you can't be discriminated against or adversely treated if you've exercised rights under the Consumer Credit Protection Act. However, Equal Credit Opportunity Act contains a $10,000 statutory limit on punitive damages with class action, unless there's a class action certified, and that relief is limited when it comes to punitive damages, the lesser of $500,000 or 1% of the creditor's net worth. Title VI, again, all of these, with the exception of the Fair Housing Act, cover residential and commercial properties or commercial transactions. Under Title VI, has race, color, national origin, and handicap, and it provides for compensatory damages for intentional violations. And again, no recovery for emotional distress damages pending challenge to Supreme Court's coming decision or congressional action. I don't know if, that's Congress is going to address that or not. Often it does. And then Elliott Larson is residential and commercial. Again, both Elliott Larson and Persons with Disabilities Civil Rights Act provide for compensatory damages only. So let's go to the policy. The Fair Housing Act has a policy to provide within constitutional limitations for fair housing throughout the United States. And what was the Fair Housing Act adopted to do to combat and prevent segregation and discrimination in housing, including the sale or rental of housing and the provision of advertising, lending, and brokerage services related to housing. And the Supreme Court in 3 decisions you see here, Traficante, ICP, Inclusive Communities Project, and Meyer versus Holly, says eradication of housing discrimination vindicates a policy Congress considered to be of the highest priority. That same, there's a similar kind of a policy underlying sections 1981, 1982. Jones versus Alfred Mayer says it's clear the act wasn't designed to do just what its terms suggest. They were discussing section 1982 to prohibit all racial discrimination, whether or not under color of law, with respect to the rights enumerated therein, including the right to purchase or lease property. Why am I bringing up the policy? It's important because the policy should be reflected in the awards issued in successful fair housing claims, or the policy should be reflected in the way verdicts, bench trial verdicts and jury trials, the way that they're reviewed, or the full avenue or realm or range of relief that's available to someone that's been a victim of housing discrimination. So policy is very, very important. Just kind of surprising for some not aware of it, Brown versus Board of Education is known for setting aside Plessy versus Ferguson, separate and unequal, right? Plessy segregated people based on race. Brown said, nope, that's unconstitutional. And so in the latter part of the Brown decision, it gets into emotional harm. Basically, it says if people have been discriminated against, and they're, were blacks, brown people, it said that emotional distress, harm, damages follow from it. To separate them from others similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. Basically saying if kids are being segregated, right, it's going to denote inferiority or lesser value to blacks, and that, right, will cause harm. A sense of inferiority affects the motivation of a child to learn. Segregation with the sanction of law, therefore, has a tendency to impair, it says retard, the educational and mental development of Negro children and to deprive them of some of the benefits they would receive in a racially segregated school system. So that was a strong basis for the Supreme Court to say that there's emotional harm when it comes to segregation. That emotional harm occurs anytime discrimination occurs. And so have to understand it. There are some decisions where they find discrimination but don't want to award damages. That's not the proper approach at all. Let's look at a couple sample awards, see what they look like. Here's a jury verdict in a fair housing case, a lending case. Did the plaintiffs prove by a preponderance of the evidence that their race or color was one of the reasons why they did not obtain a mortgage loan? Answer, jury checked yes. If the answer to one is yes, then go on to question two. If your answer to question number one is no, then go on to part E, meaning they lost and they don't get any recovery. State the amount of compensatory damages, $250,000. Go to question three. State the amount, if any, of punitive damages. The jury said $325,000. That's what verdict form looks like in a fair housing case. Here's a sample administrative law judge decision and the decision as to damages after a bench trial. After a written opinion, the administrative law judge wrote that respondents have violated 42 United States Code section 3604 A, C, and D, as well as 3617, and they have to pay the complainant a total sum of $79,782 in damages, and they have to pay a civil fine to the Secretary of HUD, $19,000, and there's other civil fines as well. And then within 120 days, the order becomes final. They shall attend 2 hours of training on the Fair Housing Act, attend cultural sensitivity training. You notice something out here too. When it comes to a jury verdict, jury typically are not going to be, all they'll do is fashion fine liability or not fine liability and fashion an amount for compensatory damage and punitive damages. But juries typically won't require additional relief such as training on the Fair Housing Act, cultural sensitivity training, and so forth. Juries don't decide those types of things. Those are done by the court. It doesn't mean that can't be done. In this case, after the verdict was put in, they could then petition the court to require additional relief, but that's not something that a jury will be deciding. So that's kind of what it looks like, right? That's the goal. And successful verdicts or bench trial decisions achieve further the policy underlying the Fair Housing Act and sections 1981 and 1982. So what are compensatory damages? What are the elements of a compensatory damages? They're sometimes referred to as actual damages. The Supreme Court said that in Curtis versus Lothar. Lothar, it treated compensatory and actual damages as kind of synonymous with each other. Compensatory damages are available in private actions filed in court, as well as in administrative proceedings filed with HUD. Sections 1981, 1982, surprisingly, the statutes are silent as to available relief. I'm not going to go into a lot of detail about the distinctions between section 1981 and 1982. Both laws cover the same protected class categories. Section 1982 deals specifically with housing. Section 1981 deals with contract rights. But in terms of how they get applied in particular cases, pretty much 1982 is what's used. There's only 2 times where you wouldn't use 1982 and rely more on 1981. One is that 1982 requires the plaintiff to be a citizen. Section 1981 has no citizenship requirement. The additional thing is that 1981 deals with contract rights. So if you have a situation where it's leaning more toward the contract rights rather than a housing type transaction, then 1981 would be used instead of 1982. When it comes to employment, it's the opposite. Almost all the cases are going to be, virtually all the cases are going to be section 1981 cases. In employment, they're not going to use 1981 a great deal. But again, getting back to the idea of compensatory damages, there's nothing in section 1981 or 1982 that mention available relief. It just says it's unlawful. Well, the Supreme Court in Sullivan versus Huntington Park addressed that and said that compensatory damages are recoverable for a violation of section 1982. There's 2 other statutes listed there which provide various kinds of relief for vindication of civil rights in federal court. That's 28 United States Code, section 1343, subsection 4, and 42 United States Code 1988. Bottom line, you get compensatory damages under both the Fair Housing Act and sections 1981, 1982. So what are the general standards? Well, courts have been clear the fair housing damage claims are viewed as tort actions, like personal injury actions, governed by general tort standards and require proximate cause. What is proximate cause? Meaning it's damages that would have flown or could be reasonably caused by discrimination. Example would be, which kind of illustrates a proximate cause argument, would be this. Let's say a landlord doesn't want children in the property. They, leasing, I don't know, 20 units, has no children. A female tenant gets pregnant, and the landlord then says, moves to evict because she's pregnant and she's going to give birth to a child. He doesn't want children, or she doesn't want children, right? So what happens is she has to move out. So let's say she finds another unit, maybe across town. She's got a second floor unit. And so she has to carry boxes up there as she's moving into her new unit. And in that process, she slips and falls and she loses her child. Okay? That's a proximate cause question. She slipped, and I don't know what, conditions were the stairs. Maybe there was snow in the stairs, maybe not. Is it fair to say that the landlord that discriminated against her because she's pregnant? Again, pregnancy under the Fair Housing Act, it's covered under familial status protection, so it's familial status discrimination. Do you think that the discrimination based on her being pregnant, based on her familial status, would be something that proximately caused her to suffer a miscarriage when she was going up the stairs, carrying boxes, moving into the new unit? Or is that too remote? Would it matter if she fell going out of the unit where she had been living till she was discriminated against and evicted? That's a little bit closer, but that's the idea of what proximate cause are. Sometimes it's real obvious if the landlord says to her, oh, you're pregnant, sorry, can't have you live here, right? And she's upset. That's real clear. There's a direct connection, proximate cause between the landlord's statement and her emotional distress damages, but sometimes it's not. So that's what proximate cause has to do with. Okay, so there has to be, that's a tort standard. So another standard for it, what's the purpose of compensatory damages or actual damage, is to do what? Put the aggrieved person in the same position as he would have been or she absent the injury so far as money can do it, as he or she would have been had there been no injury or breach of duty, that is to compensate him for the injury actually sustained. So put the person in the situation that they would have been had there been no discrimination at all. That's the goal and purpose. So what are the types of compensatory damages in fair housing cases? There's economic and non-economic. I kind of have it shaded economic in yellow and non-economic in blue. And I have type of compensatory damages, both blue and yellow, because it encompasses both. So we're going to look at economic first and non-economic second. Under economic, right, there's two types, right? There's out-of-pocket expenses and nominal damages. Let's go to first out-of-pocket, meaning just what? Monetary loss that someone incurred because of the discrimination. The cost of alternative housing, increased community costs, lost wages, moving storage, parking, packing, that kind of a thing, loss of security deposit or having to pay an extra security deposit, hotel accommodations, other temporary housing costs, medical or psychological counseling costs, lost profit on a sale of a home. If it's a real estate agent, lost commission, lost revenue or lost profits, could be advertising costs for sale of a home or a mobile home. Those are all kinds of economic that you can compute to a dollar amount, and it's out of pocket. This should be fairly clear, right? And those are again, economic. Here's a question. May a plaintiff win a fair housing case if a jury or a court declines to award compensatory damages? Yes or no? No. Let's say there's a finding of violation of the Fair Housing Act or sections 1981 or 1982, but there's no award of compensatory damages. Can that case be won? Or is it lost? Right? The answer is still win, even if there's no award of compensatory damages. And here's a recent example, Southwest Fair Housing Council versus WG Scottsdale. And jury found liability with respect to Southwest Fair Housing Council's claim that WG Scottsdale violated Title III of the ADA. The jury found what? In favor of Southwest Council against WG Scottsdale, or Atria Sierra Point is the common name of the facility. With respect to the claim that they violated the Federal Fair Housing Act and the Arizona Fair Housing Act, the jury also found liability. So they found a violation of fair housing and ADA, fair housing and ADA violations. So when it came to compensatory damages, the jury in the case said 0. No compensatory damages. The jury did not feel that compensatory damages had been proved. But it goes further. Nominal damages. A jury instruction in the case said if you find for the plaintiff, which the jury did on the fair housing claims and ADA claims, but you find the plaintiff has failed to prove damages, you must award nominal damages. Nominal damages must be awarded when a plaintiff proves that her constitutional rights, it should say statutory rights or civil rights. I don't think there were any constitutional rights at issue. Often, nominal damages are asked for in cases involving denial of constitutional rights. But here, there's no constitutional rights. Prove that her statutory rights or civil rights have been violated, but cannot prove compensatory damages. Nominal damages may not exceed $1. So the jury said, please award plaintiff $1 in the space below, indicate that defendant violated the Federal Fair Housing Act or Arizona Fair Housing Act, but plaintiff did not prove that is entitled to compensatory damages. So the jury then said $1 nominal damages. So then the jury proceeded to punitive damages, and the jury determined, based on the nominal damages, they proceeded to punitive damages and did award of $100,000. So that's why I do have it here as, if I come back over here, I have out-of-pocket expenses and nominal damages as a separate economic item. Typically, nominal damages would be $1. It's a win. Still is a win. So what happens, it should be strong advice here. A jury instruction on nominal damages and a corresponding verdict form should be requested in every civil rights case, including fair housing cases. And this has strong support. The United States Supreme Court just very recently found that award of nominal damages by itself can redress a past injury and establish injury and standing, meaning a $1 recovery is something that's recognizable when there's been shown a violation of civil rights law, and the Fair Housing Act and sections 1981 and 1982, right, are civil rights laws. So strong basis to support nominal damages. Other federal, by the way, that is a Justice Thomas, we perceive as a very conservative justice. He upheld that award of nominal damages, and he traces all the way back through the history. So it's something that's been recognized historically for many, many years, right? From the founding of our court system. So nominal damages, it seems to be rock solid at this point. I cite a couple other federal civil rights decisions. A plaintiff who has proven a civil rights violation but has not proven actual compensatory injury is entitled to award of nominal damages. Meaning, once a jury finds a violation of fair housing, they must come up with at least $1 nominal damages, even if they don't find compensatory damages. In the Gilead case, very recently, it says there's no proximate causation requirement for finding that a civil rights plaintiff is due nominal damages. It don't have to show that the defendant's fair housing violations caused any proximate, or was a proximate cause of any injury to the plaintiff, and they still can award or must award nominal damages. So it's really, really important to do it. Here's Alexander versus Riga. This is the Third Circuit 2000. Here, the plaintiffs argued the jury was improperly instructed and the jury committed error when it failed to return an award of $1 nominal damages for the defendant's violation of the Fair Housing Act. The district court in that case felt it was merely a violation of purely statutory rights and nominal damages were not required. According to the Third Circuit, that district judge's stance trivializes the role of civil rights law in eradicating discrimination. Racial discrimination, according to the Supreme Court, is a fundamental injury to the individual rights of a person, and inability to buy or lease property can be considered one of the badges and incidents of slavery. Indeed, even absent proof of actual injury, nominal damages are to be awarded to recognize violation of a constitutional rights. That's Carey versus Biff's case. They did warn, though, that you got to request the instruction on nominal damages and put it in the jury verdict. If you don't, some courts will go back and say, oh, we'll fix it. The Third Circuit will not. So it has to be timely requested in the Third Circuit. Always better to do things up front and not belatedly ask for it after a jury returns their verdict. So that's really, really important, right? When it comes to economic damages, there's out-of-pocket expenses and nominal damages. But in addition, there's compensatory damages that are non-economic, meaning they're not capable of precise measurement. There's three types here: emotional distress damages, lost housing opportunity, and loss of civil rights. First one is emotional distress damages. Actual damages under the Fair Housing Act include damages for embarrassment, humiliation, mental or emotional distress resulting from the act of discrimination. And early Supreme Court decision, getting back to Curtis versus Lowther, called it a dignitary tort, an injury to the personhood of an individual. And often emotional distress damage is the largest item of compensatory damages that's awarded in a fair housing case. Here are the general standards. First thing is medical evidence or expert testimony is not required. Harris versus Forklift, that's a Supreme Court decision from 1993 in an employment case, says that. Past that on the right, I've cited fair housing cases, which all recognize that medical or expert testimony is not required to prove emotional distress damages. So where does it come from? Typically, comes from really the complainant or complainant themselves talking about it. Heifetz in Heinz article says, without a doubt, the most important factor in determining a damage award for intangible injuries is the testimony of the victim. In addition to that, it could be other witnesses, friends, coworkers, family members. There could be medical witness if someone did receive counseling in that. They could testify that the psychological harm or emotional distress injury that occurred. Again, it's not required. I used to regularly in employment cases hire a psychologist to establish emotional distress damages. Employers would then come up with a psychiatrist, and it would be thousands of dollars to have the psychiatrist ask for a deposition of the psychiatrist and so forth. And it ended up being a battle of the experts, kind of got away from really what the case was about. So typically I won't use an expert when it comes to emotional distress damages. Hasn't really impacted the awards very much. There may be time where, where it is absolutely, when someone really suffers a mental breakdown in that. I had a case with 13 flight attendants, and both the expert psychologist that I retained and the psychiatrist that the employer retained identified one of the plaintiffs as suffering significant emotional harm. So that was very strong in that case. But again, not required, but it can really, not saying there aren't cases where that would not be appropriate, that would not be true. There are times where you would want to bring an expert in. So here's interesting thing. When it comes to emotional harm, it's a subjective analysis. When it comes to determining liability, that's based on an objective analysis from the perspective of a reasonable person in the plaintiff's position. And that Reagan versus New York Times is a discriminatory advertising case, and it talked about how a normal reader, would have experienced discrimination, saying discriminatory ads. That's liability is always determined from an objective basis. But when it comes to the emotional distress damages, that's subjective based on the analysis of the injuries suffered by the aggrieved person. In other words, what happened to them as a result of the discrimination? Two different victims of discrimination can react in different ways. I keep talking about employment. I had a sexual harassment employment case, just terrible. The owner's nephew was basically exposing himself on the job. There were two women who worked in the front office. One laughed at him, thought he was just an idiot, which he was, far more than just that. But the other one was just mortified and upset. Because of that, she wouldn't even walk through the shop area. She'd go outside the building, go all the way around if she needed to get to the back or anything to avoid him. She was so traumatized and upset, she didn't even want to go to trial, even though it was a very, very strong case. And she just refused. She goes, I cannot relive it. She was married. You would think, but again, two exact same situation. It was remarkable how two people, right, reacted completely differently to the situation. But that's what it's like when it comes to emotional distress damages. You take the person as you find them, and the goal is to communicate that to a judge or jury, what the person has really experienced and what the effect has been on their lives. There's a HUD ALJ decision. HUD v. Flowers puts it this way: housing discriminators must take their victims as they find them, and damages are based upon the injuries actually suffered by the aggrieved party, not by those which would be imputed to an ordinary or reasonable person. The aggrieved party's pre-existing emotional condition is to be taken into consideration in determining the level of emotional distress and an amount of compensation that would be appropriate. So it's real important. It's a subjective one. We're going to take a little bit closer look at that in a second. Precise measurements not required. Courts don't require it. I mean, you don't have to prove to a mathematical certainty that the emotional distress damages is $25,000 or $75,000 or $124,999. That's not possible, right? However, right, the damages still have to be proven to the extent that they're able to do, right? Can't be speculative. And so it's worth the time to develop the damages during the trial or hearing. It's worthwhile developing the damages while someone is being interviewed as the case begins. And here's a real good question. Are compensatory damages based on a purely subjective standard, looking at from the perspective of the complainant, or objective standard, a reasonable person in the complainant's position, or both? I'm going to run the risk of contradicting it, because typically judges and jury kind of merge it. This is a Dang Tran case. I've cited it. And this is correct. I took a couple paragraphs from the court's opinion. But if this one here looks pretty subjective. When Ms. Dang Tran told complaint, respondents not rent to her, she was shocked to be subjected to, basically said wouldn't rent her because of race. She was shocked to be subjected to blatant racial discrimination by someone who just had a conversation with her. She experienced subtle racism before, but never had someone be racist to my face. It was dehumanizing that he would not even let her into the home to view the unit. And she felt speechless and worthless, really. Right? When he subsequently accepted a phone call and walked away, leaving her waiting on the sidewalk for 15 minutes, she felt further disrespected and small. And you can see in the next paragraph, she describes her feelings of regret, humiliation, self-disgust, concerned about how she handled the situation, right? Thinking through, maybe she should have confronted him. Maybe she should have done something, not sure how she could have handled it because it was so unexpected. She had continued trying to plead her case even after it was clear she was respondents were rejecting her. for a factor beyond her control, her race. She testified to feelings of shame and degradation as she drove home from the subject property. The events continued to eat at her, causing ongoing distress and generating in her a persistent fear, right? That she was concerned that others would perceive her less worthy due to her race. That is a classic illustration of emotional distress damages from the complainant's perspective. But here's what the court also says. And discussing the discussion dealing with emotional distress damages, the court writes first, the nature and circumstance of the discriminatory conduct show the respondent's behavior was egregious in several ways. And they go through and list how terrible the respondent's conduct was. This starts to look objective, meaning whoever the person was, Black person seeking housing and would have experienced this kind of treatment from the respondents would suffer significant emotional harm. But this is not subjective, this is objective. It's totally looking at the perspective of what the respondents did and saying, oh, that's what, because of how egregious it was, it would have caused severe emotional distress to the complainant or to anybody experiencing this. So what's my point is I don't want to make such a fine distinction between subjective and objective when it comes to emotional distress damages. Realistically, courts and jury will look at both. They are going to look at the effect on someone shown by how what they experienced, how they felt demeaned and less valued, were victimized, but it's also going to look just at how outrageous the defendant's behavior was in committing the discrimination. So don't want to draw too fine of a line. All right, so that's when it comes to emotional distress damages. We'll talk about it a little bit later, but there can be very, very high awards for emotional distress damages. It's based on the individual facts of the case. The second measure of non-economic damages will be lost housing opportunity. And just as it says, that's lost housing, that housing was made unavailable due to discrimination. There's a number of cases that talk about that. Other courts do not consider it separately, but merge it into, they combine lost housing opportunity with damages for emotional distress because they're both intangible, non-economic, incapable of precise measurement. It can either be considered separately or it can be combined with emotional distress damages. And the amount is based on a comparison between the housing that was denied and the housing that was ultimately obtained. Right? Considerations are what? Difference between the housing opportunities, including space, amenities, safety, convenience, and so forth, locations of schools, places of work, church, and the stability of neighborhoods and other factors. Could be a better neighborhood, safer neighborhood, and other factors which are not quantifiable as out-of-pocket losses such as payment of higher rent. HUD administrative law judge put the lost housing opportunity this way. Complainant's search for housing was consonant with the complainant's placement of their children at the center of their lives. Their goal is to find housing in a secluded neighborhood close to their children's activities with a yard where the children could play safely. They also wanted a house designed to be amenable to their practice of homeschooling. The subject house fulfilled these goals. However, because respondents denied them the desired housing, they're forced to find a less satisfactory apartment. Transient nature of the apartment building, traffic near the apartment, and incidents of crime in the neighborhood emphasize the gap between the housing the complainants wanted and the housing respondents' action forced them to obtain. In addition, the apartment is far away from the family's activities and shopping and has no fenced-in area for the children to complain. Both complainant parents and complainant children lost the opportunity to live in what was for them an ideal environment, and they must be compensated for that lost opportunity. That's a good way to analyze it. So other lost just really dig into the facts of the case. In one case, would have provided a child with their own bedroom unit. And because of the alternative unit, there's a loss of privacy. It had fewer vertical steps. Sometimes the The complainant has a mobility impairment. Provided space for daughter's wheelchair, desired housing located closer to school or plaintiff's place of employment. The alternative housing deprived them of access to school busing, increasing time and travel costs. Sometimes it forces children out of school or kids out of high school. That's terrible. Forcing in high school years to be transferred to a new school. You could cause some of them to not be able to live near parents, friends, direct bus route to work, drug or convenience store, library, and park. There's one case where the alternative home had wood floors, making crawling difficult for a disabled child who could not walk. Those are all examples of lost housing opportunity. I want to come back to that Durangton case again. Are these economic out-of-pocket damages or lost housing opportunity damages? In this case, it says, again, I'm just going to quote it, a couple paragraphs, damages from lost housing opportunity. This is what the court says. Due to housing discrimination, she was forced to pay $50 more per month to rent a smaller space in a louder and less safe neighborhood with a longer commute to her job. She lived in this inferior housing for 2.5 years. The charging party therefore requests compensation for lost housing opportunity in the amount of $1,500, calculated by multiplying the $50 per month rent differential by 2.5 years. Respondents do not raise any argument with respect to this request. In this case, right, the charging party's calculation of alternative housing expense is reasonable and supported by the record. Accordingly, the court will award $1,500, right? That's $50 a month for 2.5 years to complainants and damages for lost housing opportunity. Or the question is that lost housing opportunity or is that out of pocket? What do you think? That's actually, right, an economic damage. That's out of pocket expense, $50 more a month. That's not, strictly speaking, lost housing opportunity. So sometimes they're not really clearly differentiated. Still, the bottom line is correct. The charging party should be compensated for the $1,500. But dealing with the lost housing opportunity, it should have talked about certain amenities that are not capable of precise measurement. That, strictly speaking, is what lost housing opportunities should be. This is purely economic, right? The court kind of, put in the wrong category, but still got the right result. So the last part on compensatory damages, again, there's emotional distress damages, lost housing opportunity. A third one is loss of civil rights. And I correct myself, I always put loss of civil rights in court complaints, and that guess I'm not right. I probably shouldn't do it, but early fair housing cases ordered awards for loss of civil rights. And Professor Schwemm cites some of the cases. However, there were two subsequent decisions. There's a Memphis Community School District versus the Cura case and Carey versus Fifus, where they said that proof of injury for loss of civil rights without proof of actual injury only gives rise to a claim for nominal damages. So we're already requesting nominal damages. There's no reason to double up on that request. Following that Baumgardner case, the court set aside $2,500 award for loss of civil rights because the plaintiff in that case had presented evidence and awarded damages for injuries sustained as a result of the defendant's conduct. Professor Schwemm says the loss of rights element has rarely produced a major award in Fair Housing Act case in modern times. Heifetz and hence, since the Baumgardner decision was handed down, no discrimination charge has requested damages for loss of civil rights. So the bottom line is this: loss of civil rights probably something that shouldn't even be alleged. Not worth it. So if we want to do any kind of an allegation like that, then just make the request for nominal damages. That should suffice. So loss of civil rights is really not a good remedy there. All right, so let me back up here. So when it comes to compensatory damages, there are non-economic damages, there's emotional distress damages, and lost housing opportunities. Those are the two categories. Loss of civil rights, I would not use. Nothing to be gained by alleging that. So question is, let's move to the next part. We looked at compensatory damages. Now we're going to look at punitive damages and civil penalties. Again, these are non-compensatory damages. Non-compensatory damages do not compensate a complainant or plaintiff for injuries sustained. Rather, they focus on the actions and intent of the respondent or defendant. There's two categories. There's punitive damages and civil fine. The Fair Housing Act in sections 1981 and 1982 each provide for punitive damages in court proceedings. Again, Congress removed the $10,000 cap on punitive damages in the 1980 amendments to the Fair Housing Act. There's now no limit on punitive damages under the Fair Housing Act. There's also no limit on punitive damages under sections 1981, 1982. A careful point, though, is that there's no right to punitive damages in federal or state administrative proceedings. They can't recover punitive damages in administrative proceedings. To get punitive damages, the claim must be filed in court. What are the standards? Again, the Fair Housing Act and sections 1901 and 1982 do not give standards for awarding punitive damages. Punitive damage standards is based on a line of Supreme Court decisions. In Smith versus Wade, the Supreme Court said punitive damages could be awarded upon a finding of reckless or callous disregard of or indifference to a plaintiff's rights. And Colstead versus American Dental Association, the court said the standard is not the egregious conduct of the defendant, rather, whether defendant acted with knowledge that the action violated the law or with reckless indifference to the plaintiff's rights. You notice that is less than egregious. If we go back to the Dangtron case, that was in a HUD administrative proceeding. The administrative law judge found that the conduct was egregious. Had the complainant, I'm not going to say her name, but had she made the election to have that case heard in court, she certainly was very likely to have gotten a significant punitive damage award. I'm not saying whether or not it's collectible. I don't know if it's going to be collectible. But by not taking her claim into court, she lost the opportunity to recover punitive damages. So what are punitive damage? Purpose of them? Two parts: punish and deter. Punitive damage serves to punish the defendant for his outrageous conduct and to deter him and others from similar conduct in the future. That's Smith. And again, under Colstead, later decision said it can be somewhat less than egregious. Schwem says, it says the fact that many decades have now passed since the Fair Housing Act enactment, the circumstances in the modern era that would justify a denial of punitive award in the case of intentional discrimination are increasingly rare. Agree. Once someone has established, a plaintiff has established grounds for proving intentional discrimination, pretty much punitive damages will follow, should follow, because the standard for proving intentional discrimination goes a long way to establishing grounds for punitive damages. So where do you get the standard for punitive damages or the basis for it? Really, I think the best approach I've seen, or the best standard I've seen, in jury instructions. Our Sixth Circuit Court of Appeals doesn't have pattern jury instructions for civil cases, so typically we look to other circuits and court decisions for punitive damages. The Ninth Circuit has one, a model jury instructions on punitive damages. And it says here, purpose of punitive damages to punish the defendant and deter similar acts in the future. Punitive damages may not be awarded to compensate a plaintiff. So jury's not supposed to take into consideration what the plaintiff needs in coming up with punitive damages, right? To compensate a plaintiff or put a plaintiff back in a situation where they would have been had the discrimination not occurred. That's what compensatory damages, not punitive damages. So how do punitive damages? Jury may award only if they find the defendant's conduct that harmed the plaintiff was malicious, oppressive, or reckless disregard of the plaintiff's rights. And it describes what malicious, accompanied by ill will, spite, or if it's for the purpose of injuring the plaintiff. Conduct is reckless disregard if under the circumstances it reflects complete indifference to the plaintiff's safety or rights, or defendant acts in the face of perceived risk that actions will violate the plaintiff's rights or federal law. an act or omission is oppressive, if the defendant's injury or other injuries or damages or otherwise violates the rights of the plaintiff with unnecessary harshness or severity. And here's the key one, such as by the misuse or abuse of authority or power, or by the taking advantage of weakness or disability or misfortune of the plaintiff. In a housing transaction, the landlord and tenant are really in unequal positions. The landlord has the authority or power when it comes to rental or allowing someone to stay in their unit. So you almost always find that, right? And what's the amount? Should be amount sufficient to fulfill their purpose, meaning to do what? Right? Punish and deter. What would it take? Right? I do dollar amounts. If you take someone's, entity's profit over a whole year, $100,000 punitive damages award could be docking them 1 week of income. That's not very much. Maybe that's very low. But you look at that, the punish and deter, that's very soon, you can see punitive damages can become quite large. There's a couple court decisions that show that. U.S. versus Royalwood Cooperative, this is from Eastern District of Michigan. The defendants violated Fair Housing Act by refusing to waive a no pets rule to allow the complaint to keep an emotional support animal in their unit. Had investigated a complaint, found cause, and issued a charge of discrimination. And on the middle paragraph, right, they made election to heard the complainant made an election to have the case heard in court. The United States Attorney's Office stepped in to handle it as her attorney. And they said the damages may be awarded against defendants if Joyce Grad, she's a plaintiff, has proven that either that the defendant's misconduct involved reckless disregard or callous indifference to the legal rights of Joyce Grad that are protected by the laws involved in this case. It is not necessary to show that the defendant acted with actual malice or evil towards her. Reckless disregard or callous indifference means the defendants disregarded Joyce Grad's rights, right? They acting knew that but she was being in danger of being harmed. Defendant could have taken steps to ensure she was not harmed, or that the harm was corrected but failed to take such steps. So you can see it's not real strict standard. So the jury returned a verdict of $314,000, $14,209 in compensatory damages, and $300,000 in punitive damages. You can see how, again, the largest element, when it comes to compensatory damages, the largest element typically are emotional distress damages. But beyond that, even larger than that is the punitive damages. Another case study example, right, gave the following court in Quigley versus Winter. I think this was a quid pro quo sexual harassment case. The court gave the following standard for punitive damages, and they listed 5 factors, very helpful. And the underline was in the court's jury instruction, right? How reprehensible the defendant's conduct was, whether harm suffered by the plaintiff was physical or economic or both, violence, deceit, intentional malice, reckless disregard for human health or safety, and whether there's any repetition of the wrongful conduct, deceit, whether they lied, how much harm actually resulted to the plaintiff from the defendant's wrongful conduct and from the defendant's general conduct. I don't know about that because that's getting over into compensatory damages. What amount of punitive damages? Jury must take into consideration the defendant's financial condition and amount that's sufficient to punish the defendant for his wrongful conduct toward the plaintiff and deter the defendant from others from similar wrongful conduct in the future. Got to be real careful about this is before you come up with any jury instruction on punitive damages, make sure someone is 100% up to speed as to this current standard of the Supreme Court. I'm not sure if they're allowed to take into consideration to deter others from similar wrongful conduct. It may be that the deterrence only applies to the actions of the defendant, not necessarily others. That one, I'm not sure if that's still good law on that one. And the amount of possible harm the defendant's conduct could cause a plaintiff in the future. The fourth one too is that some relationship between the amount of compensatory damages awarded. So good instructions. A couple other guidance: gross and rental amounts are used a base for determining punitive damages. If you get a tax return for a management company or property, apartment complex, you're going to see with all the expenses, maybe lower type actual profit or net income. That's not the standard for punitive damages. In the Miller Apartments and Homes Inc. case, Third Circuit 1981 decision, punitive damages was based on the defendant's gross rental amount. So that's for the rent rolls. The rent rolls with the amount that's paid each month. That's the standard for punitive damages. Then you're going to get higher amounts, like, I don't know, $60,000 a month, $100,000 a month, $150,000 a month. And right away, the financial, it's certainly relevant what the defendant's financial status is. You want to see what other property they own. It could be worth millions, and you can get the BSNA or other agreement showing their assets are very, very substantial. That's good grounds for a high punitive damage award. There is a factor of punitive compensatory damage ratios. Courts in fair housing cases permit high compensatory punitive damage ratios in fair housing cases, in contrast to other cases, because economic compensatory damages generally are small. And there's Lincoln versus Case. That's got the wrong site on that. Shouldn't be 340 US. But Lincoln versus Case, a Fifth Circuit decision, a ratio exceeding 10-to-1, far less troubling in fair housing cases, and in certain significant cases, US versus Big D Enterprises, Eighth Circuit upholding 100-to-1 punitive to compensatory damage ratio in a fair housing case. The Supreme Court, if I go to the right side, the Gilead versus Communication Service Inc. versus Town of Cromwell upheld a 27-to-1 ratio. There was a $181,000 compensatory damage award and $5 million punitive damages award. The appeal in that case is pending. The Supreme Court and Exxon Shipping, that's a maritime case. What do we call it? Affectionately, boat law case. It said that there had to be a strict 1-to-1 compensatory punitive damages ratio, meaning if compensatory damages are $15,000, punitive damages can only go up to $15,000. However, all the court appeals following Exxon have not applied the strict 1-1 ratio to civil rights cases. I cited those there. And then district court decisions post Exxon also have not relied on a 1-to-1 ratio. So clear, it can go, especially in fair housing case, you can go well beyond 1-to-1. You can go beyond 10-to-1. Big D goes up to 100-to-1, meaning, right, if you look at the case we saw out of Arizona, in that case, there was $1 nominal damages, $100,000 in punitive damages. That would fit within US versus Big D Enterprises, upholding a 1-to-1, 100-to-1 punitive to compensatory or punitive to nominal damages ratio. There is a Supreme Court case which talks about getting into attorney fees. I'm not going to get into that, but it talked about how attorney fees can be lesser when it comes to nominal damage awards, but I don't think that's really, that kind of language from the Supreme Court hasn't been followed as well. So another important factor is having the principal liable for punitive damages. In a lot of housing cases, the discrimination can be by an agent, a resident manager, somebody along those, a maintenance worker, and things like that. And you want to hold the company liable. Respondent superior means that they're liable when it comes to the compensatory damages for emotional distress, economic damages, and so forth. But when it comes to punitive damages, there must be some kind of liability on the employer or principal by what? Either participating in discriminatory action or having ratified it. In the Kolstad case, Supreme Court listed the factors from the restatement of agency, giving the factors of what can be shown that the principal ratified the actions of their agent. and either by action or knowledgeable inaction that they were involved in the wrongdoing. If you look at here, the Darby versus Heather Ridge properties, that evidence submitted to the jury regarding the employer's inconsistent statements about whether its employees received any training concerning civil rights laws. From this, a jury could reasonably draw inferences that the defendants had failed to act to prevent known or willfully disregarded the action of its employees. Washington versus Kahn case, punitive damages available where defendant was a hands-on property owner that monitored vacancies, advertised for tenants, established the criteria for selecting tenants, required the apartment managers to give them their impressions of prospective tenants, and he personally chose among prospective tenants based on their applications and the manager's comments. At a lending case in which a federal court complaint, lending discrimination case was filed in federal court, it was a year and a half before the owner of the mortgage company even bothered to read the complaint. And he did it only because he had to prepare for his deposition. He had no interest in it, did not take it seriously, had no interest at all. Right? And that's what happens. Did you investigate? Did you ask your attorney? Did you talk to the person that were alleged to have discriminated? What investigation or anything did you do? What did you do in terms of explaining to your employees about fair housing rights and things of that nature? Did absolutely nothing. They had no interest. Right? Another case, another case where they talked to the person that was, not that one, but different one, talked to the person that was accused of discrimination, kept it quiet within the company, said nothing to anybody else. Then the person ended up leaving to go for another job. 6 months later, he wanted to come back. They hired him on the spot, even though he had been accused of outward discrimination, overt discrimination, made statements against Blacks and Middle Eastern people. Direct evidence, right? They brought him back. Amazing. Those are recorded statements that he had made, which tells you, right? That's ratifying. It's absolutely ratifying. Case study, Asbury, the defendant investigated discrimination complaint plaintiff filed with HUD. Despite obtaining evidence that substantiated the complaint, the defendant took no action. Right? Because they took no action to correct it. The Eighth Circuit said that was acceptance and ratification of discriminatory conduct. Here's another one. Laus versus Hampton, owner of small apartment complex, had not been directly involved in discriminatory conduct or even knew of the incident at the time it occurred. But after the lawsuit got filed, he took no action to ensure that the agent or any other of his rental agents were informed about the need to rent in accordance with the law. Total ignoring of these duties, was knowledgeable inaction in light of his 18 years as an owner of rental properties, and his admission that he has not, even after the filing of a lawsuit, instructed his rental agent about the legal requirements of renting. That's what ratification looks like. Don't care. SWAS is one, right? Ratification need not be formal, but may be inferred from the conduct of the parties, including what action, if any, they took after the action came to their attention. For example, if you find that Carlton Apartments did not adequately discipline or provide training to Rosemary McKenzie after it was discovered that she made a discriminatory comment a few years back before making the same comment to Ms. Swass, you may find that it acted callously or indifferently or in disregard of Ms. Swass' rights and thereby ratified the acts of Rosemary McKenzie. So punitive damages, very doable, very achievable in fair housing cases. An alternative to that are civil penalties. They can be recovered in civil cases in court, state or federal court, but typically civil fines, you almost only see them in administrative proceedings, even though they can be asked for in court. And what is it? It's necessary. It's not there to punish and deter. It's viewed as being necessary to vindicate the public interest. And it also something that can be imposed separately against each individual respondent. Originally in the Fair Housing Act, I believe it was the 1988 amendments, had the amount of civil penalty at $11,000, provided the respondent has not engaged in any prior violation. within a, however, in, under HUD's regulations, it examines whether the respondent within the 5-year period preceding the date of the filing of the charge had been found guilty of a violation that could increase it up to civil fine up to $32,000. If it's within the 7-year period, had been found to committed 2 or more violations, the civil penalty could go up to $60,000. And so you can see, right, if there were prior penalties. A concern I have is a lot of the conciliation agreements have non-admission of liability, so therefore they don't. So therefore, when a new case comes up, it's not like a second violation or a third violation or more. That's the danger with it. If the evidence is strong, there should be no non-admission of liability. This also gets adjusted for inflation. So now the current, as of 2007, they're already up to $20,000 for no prior violation, $50,000 for one, and up to $100,000 for 2 or more violations. So they can be quite large. Doesn't mean a administrative law judge has to order it in the maximum amount, but they can go up to that amount. Sometimes they just do half of it, or whatever amount they feel is reflects the facts of the case. So what are the factors used to assess a civil penalty? Very similar to the factors for punitive damages. Whether respondent has previously committed violations of fair housing laws, the financial resources, nature and circumstances of the violation, degree of their culpability, goal of deterrence, and other matters as the justice may require. There's also additional penalties for housing-related hate act, right? And administrative laws are taken into consideration in favor of imposing a maximum civil penalty, whether respondent engaged in a housing-related hate act. A housing-related hate act is anything violating 818 that's interference, retaliation. And if it's accompanied by actual violence, assault, bodily harm, and harm to property, intimidation, or coercion has such elements or threat of such, then it becomes a housing-related hate act warranting maximum fine. So next part, let's go look at one last part on damages, attorney fees. Attorney fees. The policy, right? Because of congressional policy favoring enforcement of Civil Rights Act, there should be a liberal, broad construction of attorney fee statute. The Fair Housing Act puts it this way. It says relief which may be granted in a civil action, the court in its discretion may allow the prevailing party, doesn't say if it's the plaintiff or the defendant, the prevailing party can recover reasonable attorney fees and costs. And the United States can be liable for fees and costs to the same extent as a private person. Under sections 1981, 1982, also provides for attorney fees as an element of cost. It says in any action or proceeding to enforce a provision of sections 1981, 1981A or 1982, the court in its discretion may allow the prevailing party reasonable attorney fee as part of the cost. Here's the question. The Fair Housing Act states in a civil action, the court in its discretion may allow the prevailing party a reasonable attorney fees. It doesn't, it looks pretty balanced, doesn't it? So if the plaintiff wins, will the plaintiff be likely to obtain award of attorney fees? Yes or no? If the defendant wins, will the defendant be likely to obtain award of attorney fees? In other words, does the same standard apply to plaintiff and a defendant as to obtaining attorney fees? And this is, in cases that I've seen filed, attorneys who are defending the cases actually think if they're successful in defending the case, they're going to get an award of attorney fees because the statute says prevailing party. Whichever party wins gets their attorney fees paid by the other side. It looks balanced. Is that the way the law applies? Not at all. Not at all. In a court action, the likelihood of a successful plaintiff or complainant under the Piggy Park standard, it's a district court should ordinarily order that such a prevailing plaintiff should recover attorney fees unless special circumstances would render such an award unjust. And there's hardly ever special circumstances. Successful plaintiff typically will get attorney fees. let's say the Fair Housing case gets filed in court and the housing provider, management company, owner wins. So does that mean that the plaintiff has to pay attorney fees? No. The Christianberg standard is this: only time the defendant can recover attorney fees if it's shown that the plaintiff's claim was frivolous, unreasonable, or groundless, or that the plaintiff continued to litigate after it clearly became so. That's the Christianberg standard. Why is that? It's based on public policy. If an unsuccessful plaintiff in a fair housing or civil rights case could be imposed, have to pay attorney fees, word would quickly get out. Nobody would file a civil rights or fair housing complaint in court because of the fear of getting hit with attorney fees against them. So that's why it's a public policy reason why there's a different standard for a defendant as opposed to a plaintiff in having attorney fees imposed or recovered. Administrative proceedings for a complaint against a respondent awarded if prevailing party unless special circumstances render the award unjust. Similar standard as to court. When it comes to administrative proceedings for a respondent to recover attorney fees, the standard is under the Equal Access to Justice Act, and HUD has to show, an agency has to show that its position was substantially unjustified or special circumstances make an award unjust. And coming back to in an administrative proceeding, a aggrieved person has a right to intervene to become a party. If they do, they can recover attorney fees if they're successful. But on the other hand, once the aggrieved person, the victim, becomes a party, they can also have attorney fees imposed against them, but it's still a high standard. The interveners, meaning the victims becoming a party, participation in administrative proceeding must be shown as frivolous or vexatious or for the purpose of harassment. That's the only basis. So there are different standards. So to come back to the question here. So if the plaintiff wins, will the plaintiff be likely to obtain a, well, I can go back. I think I put the answers in. Yeah. If the plaintiff wins, will the plaintiff be likely to obtain an award of attorney fees? Yes. If the defendant wins, will the defendant be likely to obtain an award of attorney fees? Probably not. In other words, does the same standard apply to the plaintiff and the defendant as to obtaining attorney fees? No, it does not, based on policy considerations. So how do you compute the dollar amount? They call it the lodestar approach. Reasonable hours expended times a reasonable hourly rate. That's the standard for attorney fees. There are factors. The most important factor is the degree of success obtained in the case. Claim hours spent on unsuccessful claims should be excluded unless there's an overlap because the same work would have been done regardless of the unsuccessful claims. A real important part at the bottom, Supreme Court rejected the proposition that fee awards under 1988 should necessarily be proportionate to the amount of damages a civil rights plaintiff actually recovers, especially true in fair housing cases. Meaning, I had a case where retaliation case in state court under in the judge sent the jury back. The jury was split between 125 and 25. They ended up coming to reach a verdict, came up with 25,000. The judge didn't like it. I don't know what he did, sent him back, basically ordered him to reduce the verdict. So they came back in at 20. We did attorney fee request, and the judge says, well, the statute says may or may not grant it. So I have a discretion, a choice on granting attorney fees. So I say no. So I appealed it up to the Court of Appeals, went to the Michigan Supreme Court. In lieu of granting leave to appeal, Michigan Supreme Court granted attorney fees, right? There were no special circumstances. No reason why they weren't granted. So it gets them right back down to the trial court. Then when it came time to the rule line, I think our request was around $40,000. The judge goes, well, the jury's award was $20,000. That's the most I will give you. Right? That's wrong. It's not supposed to be proportionate or capped with the amount of the verdict. It's based on reasonable hours times reasonable rate. So that was wrong, but in lieu of having to go through the whole appellate process again, we just accepted it and moved on. But that's good to know because otherwise people won't take on fair housing cases if they don't believe that they will be compensated for doing them. I did some training before HUD started National Fair Housing Training Academy. There were attorney training sessions we do around various parts of the country where there was no fair housing activity. And Ken Holbert was, involved in those programs, long time HUD official. Ken goes, talk about attorney fees, talk about attorney fees. I thought, why do we keep talking about attorney fees? And he was right, because if you don't talk about attorney fees, no one's going to take the cases. They need to know that a $10,000 verdict can result in $125,000 attorney fees. There was one case, $5,000, I think it was $5,000 emotional support animal case, resulted in over $100,000 in attorney fees. Again, it's not how, it's supposed to be or whatever. I mean, you want them to be some connection between them, but some cases are just taking an enormous amount of time, and therefore, right, attorneys will be compensated for that. Otherwise, they won't do fair housing cases. Hourly rates. Hourly rate is calculated according to the prevailing market rates in the relevant community. Michigan does an economics of law practice study, which lists hourly rates. That's a pretty good source. You can have people file affidavits to support the hourly rate. I used, in the case Victoria Roberts, she was state bar president. She was chair of the board for our Fair Housing Center, and then after that became a federal judge. So I had her do an affidavit. I had someone, a leading person in the real estate industry, did affidavits talking about the hourly rate, showing that it was reasonable. So there's various ways that can be done. The interesting thing is the Laffey matrix is used in Washington, D.C., Baltimore area. It's a very, very protracted case to the nth degree. Laffey versus Northwest Airlines. And the district judge in that case came up with a matrix where he bracketed attorneys based on the years that they had been practicing, from 1 to 3 years, 4 to 7, 8 to 10, 11 to 19, and so forth, and very experienced litigators, and came up with an hourly rates for those. And that's been adopted throughout the DC circuit, and it's adopted by the U.S. Attorney's Office in the District of Columbia. That's an interesting approach. It's been out there a while. I hadn't heard about it just till recently. But I would think that it's something that may be worth considering in other parts of the country. And so that's another alternative approach. So it's a way to coming up with what? The reasonable hourly rate for attorneys in the DC community. So that's another interesting approach. Very important. There's other adjustments to it. There's the Johnson factors, Johnson versus Georgia Highway Express. You can just search Johnson within your circuit or within the state. You'll come up, probably most jurisdictions cite, and you follow the Johnson factors. Again, it's a strong presumption that the lodestar is reasonable, but then you go look at the Johnson factors to see if there should be an upward or lower adjustment. Typically, it shouldn't be adjusted, but there are rare cases where it does get adjusted. Fee enhancement, there's cases that have awarded fee enhancement. Edward versus Flagstar Bank, there's a 50% fee enhancement. Those are unusual cases, but courts have discretion to do it. Also, there can be recovery of fees for fees. Time spent pursuing attorney fee award can be compensable as well. So the last part is, real quick, what is a recommended approach for quantifying damages? What do you do? First, there's a worksheet on damages, should be completed for each complainant or plaintiff, should list all individuals with knowledge of the complainant's damages, especially emotional distress damages. I've got separate emotional distress damage and lost housing opportunity worksheets that are included in the appendix below. Another helpful thing is for each complainant to prepare a statement or chronology of events as close as possible to when it occurred, including events that show emotional distress and other damages. Some people remember the discrimination and the incidents and the chronology and everything exactly. Like they live it, they'll never forget it. But that's not most people. A lot of people over time, they'll start to forget, and that chronology can be really helpful to refresh their memory later on. The caution, though, is that the records are discoverable, so counsel should consider need for these records or personally prepare these records so that's to be work product in the case. All medical, financial, real estate, and other records should be obtained that may bear on items of damages or potential damages. And though not relevant to actual damages, but for civil penalties and punitive damages, all financial records of the defendant or respondent, including rent rolls, any property of real estate records should also be obtained. And then the key thing is do a thorough research of federal and state court decisions and settlements. It's a emotional support animal case. Look at all the emotional support animal cases, period. If it's a ramp case, I had a ramp case, denial of a ramp. I looked at all the ramp cases as best I could. There weren't a lot, but I found some. I found most of the time people allow someone to put the ramp in, as they should. The DOJ Housing and Civil Enforcement Section case has cases including complaints, verdicts, and settlements and consent orders. That's a great source at the U.S. Department of Justice website. HUD has ALJ and HUD Secretary decisions. I have this site there. A significant number of the HUD decisions involve damage calculations. In contrast to court decisions that often typically don't spell out damages and how the damages are computed. And now it's increasing that the HUD decisions are also available on Lexis and Westlaw. HUD has a fair housing enforcement activity containing charges and conciliation agreements. Again, I wouldn't necessarily take those amounts as fixed because, again, during the HUD process, there's no punitive damages, which you would get in court. Same thing with the HUD, ALJ, and Secretary decisions do not take into consideration punitive damages. On some of the HUD, DOJ, there's going to be more because when HUD gets involved in fair housing cases, they will be handling them in federal court where punitive damages are available, as well as civil fines. I would take civil fines as analogous to punitive damages. And one last thing, though costly, additional source of verdicts and settlements in fair housing cases include John Relman's Housing Discrimination Practice Manual and Professor Schwemm's Housing Discrimination Law and Litigation. Both of these books list awards of damages and attorney fees, as well as sample pleadings at all stages of the litigation. If they're too costly to purchase and the volumes themselves and the annual update subscription costs are extremely costly, these texts should be available at local law libraries. I can't say enough about both Relman's Housing Discrimination Practice Manual and Schwemm's Housing Discrimination Law and Litigation. We have both of those in our office. We make them available to attorneys that handle our cases. Happy to do so. It's amazing how helpful those are. And by going through this process, looking for similar cases and similar amounts, then you can start to come up with a good valuation of a case. And it's not based on your opinion, my opinion, someone's opinion. It's based on what has been found in other cases. A good example of that will be, and I was going to put talk about insurance as part of this webinar. I think it deserves its own separate webinar, and that's what I'm going to do. But insurance carriers, when they insure fair housing cases like they do other types of claims, they want to know what are values, what is the likely value of this case based on liability and damages, and they want to see evidence in other dollar amounts in other cases. Like, well, give us some precedent or whatever. I'm thinking, why? Why should I give you all that information? Well, insurance adjuster just wants to know how to value it. Once you provide that information, they may just up and pay it and be done. So it's very, very helpful to have that information. It's, the information we're describing here, not only in a given case, but also when it comes to dealing with cases where the defendant is or respondents have insurance coverage. Just real quick on the appendix, mostly distress damage worksheet, lost housing opportunities worksheet. There's various formulations of this floating around. And here's the emotional distress damages worksheet. And you can see the symptoms, severity, frequency, duration, ongoing. And in your own words, how did housing discrimination hurt you? Explain how it affected personal relationships, views of yourself and others, job performance, willingness to look for housing. What I like about this one, it asks for witnesses. Anyone who you have told about how you were hurt by the housing discrimination, including counselors, doctors, friends, and relatives. Real important to get that information down. And then there's a lost housing opportunity damages worksheet, and these list a way to compare move out property, the subject property that someone's seeking, the move to property, and the current property. And so forth. Best thing about property, worst thing about the property, commuting, specials, and so forth. So these are pretty helpful. All right, so we've covered, right? Fair housing policy, sample verdicts. We went in detail on compensatory damages. We talked about punitive damages and civil penalties. We touched on attorney fees and costs. Well, I didn't cover insurance. I'm going to cover that in a separate one. Recommended approach to damages. I want to thank everybody for participating. I wanted to stick it within an hour and a half. I'm pretty close, 4 minutes over. I will do at a later point in time, cover insurance coverage in detail. In the chat, if you have an opportunity, please list what else you'd like to know or some future training topics, or send an email or let us know what you would like to have covered. There's additional trainings going forward on our website under events and trainings. Again, our services, we do housing, complaints, intake investigation. We have testers go out. We help with enforcement. We have cooperating attorneys that can represent somebody on a contingency basis. All of our services are provided free of charge. We also answer other housing related questions. We may deal with municipalities on, coming up with a source of income or other tenants' rights ordinance, different things like that. Even at the state level, we may assist with that and some of those policy issues. We do training and education. If you haven't gotten the training, it's because you haven't asked for it. We provide it. We do remote, we do it by Zoom and targeted to your needs. I had training in Sterling Heights, I had training in Warren, training in Port Huron. You get the idea. But happy to provide that. Again, we can feel free to call us at any time, 313-579-FAIR, or go to our website, reach us that way at fairhousingdetroit.org. Thank you again for participating. And again, we're always available to answer questions. And I will stop the recording at this point, and we will then stay on to answer questions outside of the training, for things that people want to discuss with the recording off. So thank you so much. Appreciate taking time from your busy day to be with us. And again, thanks again for participating.